Good afternoon. It's 12 o'clock here in Washington, D.C., the heart of the empire where I am currently based. And it's 11 o'clock in Chicago, where I'm joined by journalist Kevin Gosztola. Kevin is, of course, the managing editor of Shadowproof and curator of the Dissenter newsletter. And this podcast is brought to you by Defending Rights and Dissent, an organization that defends your right to know and your freedom to act. And as an organization concerned with both your right to know and your freedom to act, the 103-year culmination of Espionage Act abuse into a point where we now have the U.S. government asserting the right to apply its Espionage Act extraterritorially to prosecute journalists who publish truthful information they don't like is of grave concern to us. And while the mainstream media has a mixed record on this topic, independent journalists like Kevin have been doing fantastic work in the trenches and on the front lines of this case. In Kevin's case, for 9 years, almost a decade. Is that correct?
Yes, I have. Yes.
And Defending Rights and Dissent has been serving as a clearinghouse of information to bring you voices like Kevin's. On the past broadcast, you've seen other journalists like Ryan Grimm of The Intercept, Stefania Morici, the Italian investigative journalist, whistleblowers like Jeffrey Sterling, who have been prosecuted under the Espionage Act and have been in the jail where Julian is likely to be held. So we're sort of standing up to bring you all these different voices that you should be hearing. And unfortunately, Anderson Cooper isn't booking Kevin, but I wish he would. Kevin, thank you for joining us today. We're here today because the UK High Court has made a decision in whether or not Assange can appeal to the UK Supreme Court. My understanding is that the judges who made this decision are also the ones who made the High Court decision that's being appealed. And it's ultimately being considered a victory. WikiLeaks, Stella Morris, and many others are touting this as a victory, which it is. But it's a very complex and sort of very convoluted decision. And as we've talked about before, unfortunately, in these sorts of legal cases, they oftentimes turn on very, very narrow niche legal issues that don't seem to fully grasp the fact that we're talking about a torture victim and whether he will be extradited to his torturer, whether he will quite possibly live or die, and whether or not we have a First Amendment anymore in this country. So, Kevin, could you explain and walk through us what this stage in the proceeding is, and what are the grounds on which Assange can appeal, and what are the grounds on which he cannot appeal?
Yeah, and I was looking down on the frame, fumbling, because I wanted to make sure I had the pronouncement from the court before me, just so I can read their words before I give you my own words. These are some of the words of the High Court of Justice and what they had to say. So basically, what happened is at the High Court level, which, as you were setting up, they were the court that granted the U.S. government's appeal back in December. And so Julian Assange lost. And then that decision was sent back down to the district court level. But it was also an instruction was sent to that court that barring an appeal to the Supreme Court, that it should be sent on to the Home Office, which is a lot like it's like it's a cabinet position. I think it's kind of like a Secretary of State, so to speak, and that she could have authorized. It's Priti Patel is the Home Office Secretary. If anybody's in the UK and I mess this up, please let me know.
I don't think she's quite like a Secretary of State. I think it's a complex thing that exists in parliamentary systems where they're... Anyways, go on. I'm sorry.
Well, she's handling something that I think typically the Secretary of State would sign off on here in the United States, which is why I'm saying that. And so now what we have from the High Court is this, that these points of law that Julian Assange's legal team asked the court to certify, and they asked them to certify this because if they agreed they were points of law, then they could be questions that were appealed, or I guess to make up a word, appealable to the Supreme Court. And then that opens the door so that they can go to the Supreme Court and make the appeal. This is entirely convoluted. and really no way to run a legal system, in my opinion. But it is how things work and function in Britain. And so the reasons that are articulated from the High Court today are that Julian Assange sought certification in respect of 3 points of law, the first of which centered on the circumstances in which an appellate court may receive assurances from a requesting state concerning the future treatment of a requested person if extradited. Okay, so that point of law was certified, and it turns on what circumstances can an appellate court receive assurances. Those are the diplomatic assurances, which we'll get into and enumerate and describe for people who are confused about what the diplomatic assurances are. But it was the question of whether the appeals court could receive these assurances from the U.S. government, which were not before the district court in the extradition proceedings. That is, that Judge Vanessa Barretza ruled on this before the U.S. government ever came to her with assurances about how they would treat Julian Assange in the United States. And so then they said, we do not consider the second or third points to raise certifiable points. So there were other things that dealt with the special administrative measures and whether he'd be held in a supermax prison in the United States, the lack of access to mental health care, the issues related to his transfer to Australia, potentially, things that were raised, questions that were raised by, the legal team. And they said those points of law have actually been settled at the appeals court level, so they weren't going to certify them for further discussion by the Supreme Court. And then they say, so far as the first point is concerned, although the law in the appeals court is settled on the assurances, the Supreme Court has not considered this question about whether these assurances can be received after the judge made her ruling. So assurances are at the heart of many extradition proceedings, and therefore that would be why they consider it a matter of public importance. But then procedurally, they did refuse leave to appeal. And a lot of people are fixating on this refusal to grant the permission to appeal, when in fact it's just a procedural outcome that is typical with the appeals court. And it just ends their role. They no longer have any responsibility to it. And then now the Supreme Court is free to receive the appeal from the Assange legal team and decide if they want to hear it, just in the same way that the High Court was able to decide whether to hear the U.S. government's appeal.
Yeah, and I believe the overall takeaway has been this is a victory. We're going to talk about some of the drawbacks about this, but I mean, Stella Morris was outside the courtroom. I think we might have a video of her speech. Do we have that video?
What happened in court today is precisely what we wanted to happen. The High Court certified that we had raised point of law of general public importance, and that the Supreme Court has good grounds to hear this appeal. The situation now is that the Supreme Court has to decide whether it will hear the appeal. But make no mistake, we won today in court.
We won today in court, and that is, I think, the banner takeaway here, because if this case had not been certified to go to the Supreme Court, it would have gone to the Home Secretary. On the other hand, though, and this...
Well, yes, but what it would have meant is that the next move that the Assange legal team has would come into play, which is that they can activate their appeal of the district ruling on the press freedom grounds, and they can bring that before the appeals court. But we really don't want it to get there, because if we can, if they can win on the matter in which the U.S. government lost initially, then it's just over. As far as keeping Julian Assange in a jail cell, then he would have to be freed, and then they're free to go about challenging the ruling of that district court that was highly problematic and troubling for global press freedom, but they can go through that appeal with Julian Assange outside of prison and home with Stella and his 2 children, which is what they want. So they've been trying to get him out, end this case before they do that appeal.
Yeah, and I just wanted to read Amnesty International's reaction to this decision today, because I think it brings in an important perspective that isn't in conflict with the fact that Assange and his team won today, but does point out how some of the narrowness of this has concerning impact for human rights advocacy. Amnesty released a statement saying, while we welcome the High Court's decision to certify one narrow issue related to the U.S. assurances as being of general public importance, and so to allow the Supreme Court to consider granting an appeal on this issue, we are concerned the High Court has dodged its responsibility to ensure that matters of public importance are fully examined by the judiciary. The courts must also ensure that people are not at risk of torture or other ill treatment. This was at the heart of the 2 other issues the High Court has now effectively vetoed. Torture and other ill treatment, including prolonged solitary confinement, are key features of life for many people in U.S. federal prisons, including those imprisoned on charges similar to Assange. The ban on torture and ill treatment is absolute and cannot be upheld by simple promises from a state that it won't abuse its people. So I kind of want to take this moment to go in and discuss very briefly, because I know I promised you I'd only keep you for 15 minutes. I'm always promising you I'm only going to keep you for a set amount of time, and then I keep
late.
you over and over and over. You're very charitable. But what are those assurances? And, I wrote a very lengthy piece in Jacobin about why I was disturbed by them, but I'm curious to get you. I give mine.
Yeah, so, the important thing about that Amnesty International statement is that it reflects probably the reservations of human rights organizations in looking at this decision, because they are going to work on issues beyond Julian Assange's case, 5, 10 years, 15 years into the future. And what does it mean that the High Court of Justice doesn't want to examine the issues that the Assange legal team brought to them about how somebody extradited to the U.S. could face torture or ill treatment, and whether they're, they call it Article 3 rights under the European Court of Human Rights, or even the European Charter of Human Rights. I think it's a human rights charter. And what does it mean that they won't consider the questions that are raised seriously? This is a lot like what happened with Vanessa Barrett's decision. People were breathing a sigh of relief that the U.S. government had lost and Julian Assange was not going to be authorized for extradition, that he won because the judge acknowledged it was oppressive for mental health reasons. Yeah, you look at 80 to 90% of that ruling and it accepts a lot of things about Julian Assange that are damaging to global press freedom, and whether journalists, have rights to engage in freedom of expression. So those had to be taken seriously, and there were numerous press freedom organizations that celebrated that Assange was not going to be extradited at that moment, but they were stern in saying what was faulty and flawed about the judge's decision. So we have that same dynamic today with human rights groups. The assurances that the U.S. came forward with after they had lost, and brought forward only because they had lost. This is not something that prosecutor Gordon Cromberg in the Eastern District of Virginia cared to share with the court or put forward to the court when he was making pronouncements that are false about how people are treated in jail or in U.S. prisons. But what the U.S. government said, was that if Julian Assange was brought to the United States, they would not put him in a supermax prison after trial. So he would not go to ADX Florence, Colorado. And they also said pre-trial, but pre-trial detainees are never sent to a supermax prison. So that doesn't make any sense. But that's not something the High Court bothered to test. And then there was the issue of he will not be put under special administrative measures, which are designated by the Attorney General, if he is brought to the United States. Now, with both of those, there are major loopholes that are similar. If he engaged in some future act in which those people who provide input that is considered for those designations, let's say they gave the Attorney General something that raised alarm, or he engaged in some future act, like, I don't know what that would be. They didn't give him any notice of what that future act could be, but then they might put him under special administrative measures, or they might send him to the supermax. What they also don't tell you is that they have communications management units that are in Terre Haute and Marion, Illinois. Terre Haute's in Indiana. And Marion, Illinois, the penitentiary there is where Daniel Hale, drone whistleblower, is being held right now. And I'll just very quickly remind people that assurances were offered by the Justice Department in that case to his lawyers that he would go to FCI Butner Low, a low security prison in North Carolina, and that is where he would be held to serve his sentence. He'd be given some psychiatric treatment for his post-traumatic stress disorder. And then he ended up being put in a transport vehicle and taken to the penitentiary in Illinois, arrived there, and then learned he's going to be put in a communications management unit, and he'll no longer be confined in the conditions that were discussed before the court. The judge has no review of this at all. The Justice Department gets to do this without any objection or any review by a judge.
Yeah, and I just want to point out that in Gordon Kronberg's declaration to the court, he explicitly states it's possible that Julian Assange could go to a communications management unit. And he then proceeds to give this very sort of rosy depiction of one. And I shared his declaration with Rachel Maripol, who is the lawyer from the Center for Constitutional Rights, who has been litigating against CMUs for over a decade, I think, as long, if not longer than this case. Things go very slowly in the U.S. legal system as well. I mean, and her comments were just like, he says they do all these things, but this is literally the fact that they're not doing them has been the subject of litigation for like a decade now. And they also concede in this assurance that Julian Assange, if he's sent to the William G. Truesdale Alexandria Adult Detention Center in Alexandria, Virginia, where Chelsea Manning was held and tortured, where Jeffrey Sterling was held and has described his treatment to us, where I believe Jeffrey Hammond was also held when he was being put before the WikiLeaks grand jury, and he fully concedes that he could be put in. He says there's no solitary confinement, which is a lie. They are in administrative segregation, and per Kronberg, this is Kronberg's assurances, people in administrative segregation are kept in their cells 22 hours a day, which we know from how Chelsea Manning was treated. And the United Nations standard minimum rules for treatment of prisoners, called the Nelson Mandela rules after Nelson Mandela, who was infamously confined, define solitary confinement as 22 hours or more a day without meaningful human contact. Under the Mandela rules, solitary confinement in excess of 15 days constitutes prolonged solitary confinement. Two successive U.S. Special Rapporteurs on Tortures have stressed that solitary confinement violates international human rights law, is at the very least cruel and degrading treatment, and it can in many cases arise to the level of torture. My opinion is that in Assange's case, it would reach the level of psychological torture. So like these assurances, even if you table the loopholes about ADX Florence and the special administrative measures, they completely are upfront that they might put Assange in a CMU, they might put Assange in administrative segregation, and under the Nelson Mandela rules, these violate international laws. So these are essentially assurances that they're going to torture Julian Assange. And I don't know, I feel like that doesn't get out there enough. I know I always go off on this on every one of these broadcasts, and you're probably all sick of hearing me about this, but I think it really has to be stressed that the best case assurances, ignoring all of the loopholes, are in direct violation of the Nelson Mandela rules.
Well, but this is the opportunity to state the issues again so that everyone knows what the legal team is dealing with going forward. I mean, they haven't been able to get this before the Supreme Court. So a lot of these issues with how he would be treated under SAMS and in ADX Florence, and the fact that he will have a limited, if not a total lack of access to mental health care. And the other thing is that they made an assurance that there would be a clinical psychiatrist that would be assigned to Julian Assange. The problem is the Bureau of Prisons does not provide enough resources and staffing for these facilities. So even if you want to assume the best motives of doctors that are employed by the Bureau of Prisons to work at these facilities, wherever Julian Assange is sent to serve out his sentence, let's say Marion, in a CMU, just for the sake of our argument, if they do not have the staffing, they can de-rank his needs for mental health treatment so that he doesn't need to be provided care. And they can focus on other prisoners who are obviously and in more need, probably having psychotic breaks and screaming and yelling and things of that nature. And if Julian Assange isn't doing that, then he's not going to get a doctor. And they'll do this. So, they can also deny, they can say that they believe Julian Assange is lying about his mental health conditions or even his physical health conditions, which is something that isn't, I'm not making this up, because the prosecutor in the Crown Prosecution Service actually said to the district court that Julian Assange is reading the British Medical Journal to fake his symptoms when he goes before Michael Kopelman, who was the psychiatrist that was treating him regularly during the first 6 to 8 months that he was there in Belmarsh Prison. So prison doctors are known, and so are wardens and prison staff, to accuse prisoners of exaggerating their symptoms so that they can get attention, so that they can accuse prison authorities of abusing or even torturing them. And that's something they frequently do, is accuse prisoners of being the ones who are in the wrong in order to cover up their own wrongdoing. And that is the sort of future that lies ahead for Assange if he is in a U.S. prison. There's well, can I just go ahead if you want to speak to that?
No, you go ahead.
Well, I wanted to make sure we mention the issue with Australia, because that is an assurance that was put before the court. And I'll just restate that my view is that this is a meaningless assurance, in the sense that if you read the language that was given to the High Court, it only says that they will allow Julian Assange to apply for a prisoner transfer to Australia, which is something that anybody coming from Australia would be allowed to do. It doesn't say that they will grant it. I mean, they're not saying that, like, right now they acknowledge there are grounds for Julian Assange to be transferred out of a U.S. prison to not serve his sentence in the U.S. if he is convicted, which they could do. They could say that we believe that no matter what, if we win our case in the United States against Julian Assange, then we don't want to keep him in our custody and we will transfer him to Australia straight away. But they're saying we will allow him to apply, which is different than saying we would grant an application for a transfer to Australia. So those are things that are tied up in diplomatic relations between Australia and the United States. Generally speaking, I don't think that this really has as much significance as people have given it. They've made it seem like it's a big deal that he could go to Australia and avoid abusive treatment in the US. And again, I'll say, what does it say about our system, our mass incarceration system in the United States, that we can extradite people here, we can put them on trial, but we can't guarantee that they won't be tortured or cruelly treated. And so in order for them to be put on trial, they have to go serve their prison sentences in another country.
And I just want to briefly raise the issue of the Alexandria Detention Center again, where Assange is almost certainly going to be held awaiting trial. I've interviewed people who have been there. I've interviewed people who had clients there. My understanding is that there is no therapy or counseling offered there. The only mental health services they offer is medication management. So that in of itself is extremely disturbing. And we can, since we're in DC and it's right next door, we can go out and do these interviews and find out what life is like there. And it's very grim. Kevin, I want to go on to the final question of the day. What is next for Assange? And this
Yeah. But let me make one quick point here, because if he's in Alexandria Detention Center, he's not close to his family and he's further away from his friends. And these are people, anchors that we know have provided support to him even throughout the lockdown conditions at Belmarsh during the COVID pandemic. Being able to make phone calls to those people. Those phone calls become long distance phone calls if he is in Alexandria. And having those individuals that he could call up. There's also something called Samaritan's Hotline in the Belmarsh prison where you can call. This is like a suicide hotline. So if you're having thoughts that are affecting you, you can call up somebody and you can have them talk you down. And he's used that phone. And that, I don't know that there's even a service that we offer U.S. prisoners here in this country so that they can handle those thoughts. So if he's here, he's even more isolated than he is isolated right now in Belmarsh. He's getting less medical treatment, less mental health care than what he has with his assigned doctors in Belmarsh. And he's here and very vulnerable. And there will be deep questions about what will happen to him during the pretrial phase. We don't even have to deal with the post-trial phase or what will happen while he's going through trial. It'll be of huge significance what happens before trial, because that's where Chelsea Manning attempted suicide before she was finally allowed to walk out free and after resisting the grand jury subpoena. So what happens next? They go to the Supreme Court. They file their point of law. On this point of law, they file their appeal. Like we said, it's very narrow, but that narrow matter can make all the difference. The beating the U.S. government on the fact that it's oppressive on mental health grounds was a major reprieve for Julian Assange. Winning on this narrow issue, especially if the Supreme Court is an ultimate decider, could be a big deal and cost the U.S. government their ability to extradite Julian Assange to the United States. I mean, think of this. The U.S. government may not get Assange to the United States because they were not forthright and honest in putting forward morally and falsely and these bankrupt assurances that really aren't backed up by anything, not really worth the paper that they're on. But still, had they come forward to Vanessa Barretzer before she made her ruling, had they done this within the main extradition hearing in September of 2020, then they may not be in this predicament right now. They have to save their case. I'm just saying, I think the U.S. government is in a position right now where they have to guard against Julian Assange persuading the Supreme Court, because what the Assange legal team lays out in their filing are legal precedents in which assurances are not supposed to be brought forward after the district judge rules, and that there is some settled law on this question, even though the high court is saying the Supreme Court hasn't heard this matter before. So if they step forward and take this, then they're going to hopefully resolve this question. If it's in favor of Assange, then he could potentially walk free from Belmarsh. If it's against Assange, then the U.S. government will have won, but that means that Assange's legal team can appeal the district court decision and they can reset this and focus it on the core press freedom issues that animate and drive a lot of the opposition to extraditing Assange. And I'll close with this main point, which is this has been the thing that needs to happen all along. But today, as we debate whether this is a victory or not, which I think is not really a valuable discussion to spend our time having, rather than doing that, we should be focused on the actions of the Biden administration and Attorney General Merrick Garland, who I know you were just doing a demonstration in DC outside the Justice Department and protesting the fact that these charges have not been dropped. The matter at hand is that the charges have not been dropped by Attorney General Merrick Garland, by the National Security Division of the Justice Department. The crucial question is not whether he won at the high court today. It's not whether the Supreme Court will hear this appeal. The critical question remains, will Joe Biden and his administration continue to pursue a journalist, keep him in jail, and try to bring him to the United States to put him on trial and jeopardize global press freedom in a way that empowers authoritarians in the very countries that they are claiming to oppose today through U.S. actions, whether it be in Russia, China, Iran, Venezuela, Azerbaijan, any of these countries, Cuba, whatever, any of these countries that they're saying there isn't press freedom. They don't have any credibility so long as they're trying to extradite Julian Assange to the United States.
And the immediate next step is for the Supreme Court to decide whether or not they're going to hear the appeal, right? That is
exactly. That is the next thing that is on the table. Excuse me. So
we are Defending Rights Dissent are completely in agreement with your perspective. We are a U.S. domestic group. We're not an international rights group. We're not a British group. All of this time we've spent thinking about the British legal system very odd, a bit challenging for us as a U.S. constitutional rights-based group. But we have been out there on the Capitol Hill, meeting with offices, meeting decision makers here, trying to get them to put pressure on the Biden administration, trying to get them to reform and amend the Espionage Act. So Kevin is correct. There is plenty of work to be done domestically on this issue, as well as the broader Espionage Act struggle. I would invite you to get involved with that work by visiting rightsanddissent.org. And Kevin, where can people read your excellent reporting?
If you go to the dissenter.org, dissenter, dissenter.org, that's where I publish all the updates on the latest developments in Julian Assange's extradition case, and any other related matters. There's also whistleblower stories there that I try to cover. And if you sign up there, you will stay up to date on what happens next.
Kevin is hands down the best reporter covering the war on whistleblowers in this country. I feel extremely qualified to say that. And without his reporting, the work of Defending Rights Dissent would not be possible. And that's part of the reason why we put these programs on, where we bring you the people who Anderson Cooper should be having. I don't want to single out just Anderson, but maybe
Jake Tapper.
Joe Scarborough should be having on, but are not. Thank you for joining.
God, that would be savage. There'd be like 4 people telling me that my viewpoint is not center enough.
Okay, that might be me sending you on the Scarborough. We're getting greetings from France, Australia. One person, it's 3 a.m. in Australia, and they're watching us. Someone is greeting us from France. We have getting greetings from all over the world, Kevin. As they said in Chicago in 1968, the whole world is watching. That's the end of our broadcast, and I hope you will sign up on our website so you can get notice of future broadcasts like this, because as this legal proceeding continues, we're going to both be advocating domestically in the U.S. and bringing together international journalists and experts to explain to you what you should know about the case. Have a good evening or afternoon.